Good afternoon, everybody, and especially to Jenny Johnsen and Saraphoena Koffron. We are here today to talk about Quadros, and I know it's a little bit of overwhelming topic, and a lot of people don't have to deal with them very often, except in maybe a collateral way, which is an even more important reason to understand what they are and why they're important. So today we have Jenny Johnsen. A lot of you know Jenny. She's a family law attorney in Grand Rapids at the law firm of Johnsen and Saraphoena, but also as of the past couple of years, she is the principal owner of a new Quadro company called Rapid Quadro. And I had the pleasure of seeing Jenny present on this topic last year. And it was like, even though I've been to many Quadro presentations and have had lots of questions over the years, it was so informative and helpful. So I really am looking forward to Jenny sharing some information with everybody today. We also have Saraphoena Koffron, who is a partner at the Kalamazoo law firm of Austin and Koffron. And of course, you know her as a family law attorney. And the reason I invited Saraphoena was because she wrote the amicus brief in the Michigan Supreme Court case of DRO v. DRO, which was examining whether Johnsen, the published case from the Court of Appeals, was correctly decided. So we're going to talk about those cases today, and Saraphoena can share her input. So first of all, welcome and thank you, Jenny and Saraphoena, for being here.
Thank you for inviting us.
Thanks, Lisa.
So we're going to start off with a little bit of basics for everybody, probably for the first 10 minutes, and then we're going to dive into all kinds of problems that we see and what to do about them, and really how to avoid problems. So the first question really is for Jenny, is what is a Quadro and why do our clients need one? Jenny.
Thanks, Lisa. Well, most of you probably know that QDRO stands for Qualified Domestic Relations Orders. Basically, if in a divorce situation you have a retirement benefit of some kind that is being divided between one spouse and the other, chances are pretty high that you're going to need a domestic relations order. A Quadro, the Q stands for qualified, which means these are retirement plans that are private sector employer-sponsored retirement plans that are governed by the Employee Retirement Income Security Act, or ERISA. So a lot of times we refer to all domestic relations orders as Quadros, but really the Q part is related to any sort of qualified retirement plan under ERISA. There are other types of plans that we see all the time in divorce that are subject to division. And while they are usually a domestic relations order is needed, there are different types of domestic relations orders like EDROs, which are eligible domestic relations orders. Those are retirement benefits that are governed by the EDRO Act here in Michigan. And so those are different. They're similar to qualified plans, but there are different nuances related to that.
And the EDROs I've seen have to do with like school teachers. Are there certain like industries that use certain types of DROs?
Yes, that's exactly right. EDROs are actually related to defined benefit plans. So there are a number of defined benefit plans here in Michigan that are governed by the EDRO Act. So whenever you see a state police or a state police pension plan, teachers' pensions, there used to be a judicial pension system, any city or municipal systems, those are usually subject to the EDRO Act. So that's one way you can kind of distinguish between one plan or the other. Is, are you dealing with the public sector or Michigan plan? And if so, chances are high that you are in need of an EDRO, not a Quadro.
And you said it's a different statute. So
correct.
Right? Okay.
Yes. One is the EDRO Act is a Michigan statute. ERISA is obviously a federal statute. And it can be a little confusing because sometimes, for example, teachers will have a pension system. They're participants in a pension system that's governed by the EDRO Act. So you need an EDRO for those divisions. But then they're also a participant in a 403B, let's say a VOIA managed 403B or something like that. Well, those 403Bs are actually ERISA governed private sector retirement plans. So sometimes you have a situation where you need an EDRO for the one pension system and you need a Quadro for the other retirement plan in play, and it can be the same person, as a participant in both plans.
Got it. And I've heard of a CoApp. What's that?
So those are court orders acceptable for processing. I don't typically call them that, actually.
What do you call them?
I usually call them order dividing FERS, a federal employee retirement system, or a civil service retirement system. And those are federal retirement systems. You see those anytime there's a federal employee. Again, the federal employees retirement system, the civil service retirement system are defined benefit plans. So those are your pension systems. And then also there are thrift savings plans under, federal employees that have thrift savings plans in addition to FERS or the CSRS plans. The TSPs function a lot like, your average defined contribution plan. So they're a lot like a 401k, and they're divisible through an order. I usually call those orders dividing TSP benefits. And actually, I don't know, this must be a recent development because the TSP orders used to be very, very simple to draft. They were 2 pages long and they were just really easy breezy. And now there is a packet of papers about that thick. And there's actually a form court order that I think the TSP processing unit wants you to use, and then some other forms that you need to fill out in addition to the TSP order in order to process those.
So, all this is like great. I can listen to you and I'm understanding the words you're saying, but like when it's time to work on a case, is this something that somebody like Rapid Quadro, for example, could help an attorney figure out what there is, right? Like at the beginning of the process, or as they're going through the divorce proceedings and representing their clients?
Yes. And I would say the number one tip I would give practitioners is to figure out what types of retirement benefits you're talking about, because the orders are different. The liquidity is different. The tax implications are different. There are early withdrawal penalties sometimes in play. And I am more than happy to talk with any practitioner if they want to give me a call and say, hey, help me figure this out, because it makes things so much easier. I think one of the biggest challenges from a drafting perspective that I run into is I'll get a judgment of divorce and it'll say something like, the parties are, the plaintiffs, Charles Schwab IRA will be divided 50-50 as of June 1st of 2021, plus or minus gains and losses. And, Jenny Johnson will prepare the Quadro. Well, because it's an IRA, first of all, you don't need a Quadro. Sometimes if there's enough specificity in the judgment itself, you can utilize the judgment to divide IRAs. And use the plan custodians or the IRA custodians' internal transfer documents or a letter of instruction. But also more than that, IRAs are different than qualified plans under ERISA. So IRA custodians are not going to be able to go back to a valuation date in the past and calculate earnings and losses on those funds. So they'll be able to do a dollar amount transfer or a percentage as of the date of transfer, or a transfer of shares a percentage of shares, but they're not going to be, so in other words, you're getting a judgment of divorce that expresses the intent of the parties. But when you're turning that into a court order that the custodian can use to actually divide up the account, it's not possible to effectuate the party's intent. So it's really discouraging when I have to go back to, the parties or the attorneys and say there's a little bit more work that needs to be done because we're not going to be able to do what the judgment of divorce wants you to do. The other problem with that is that in a 401k situation, there are distribution elections that somebody is going, the alternate payee is going to be able to make, including possibly taking a cash distribution and avoid an early withdrawal penalty if the person's not if not yet 59 and a half. Well, if you go to withdraw money from an IRA, you're not 59 and a half yet, those rules don't apply. So you're going to be hit with those early withdrawal penalties. So that is really challenging from my standpoint to have to tell parties, I know you were expecting to be able to take this money in cash, and unfortunately, there's a hiccup in this process. Even worse than that, I've actually had folks that their divorce attorneys were mistaken a defined benefit plan or a pension plan for a defined contribution plan or a 401k. So then the parties are expecting a cash lump sum so that they can use to pay their attorney fees or, have a rainy day fund or fix their furnace or something like that. And then I have to be the bearer of bad news to tell them, nope, sorry, this is a defined benefit plan and this is representative of a future monthly benefit at a retirement date. So that can be pretty tricky too.
So how early is too early to bring you on?
I don't think there is a too early, honestly, Lisa.
Okay.
And I say the earlier the better, because as far as qualified plans under ERISA are concerned, the definition of an alternate payee includes spouse, former spouse, dependent child. So you don't necessarily even have to wait until the conclusion of the divorce matter to process your Quadro and send it on to the plan administrator if there is an agreement on the division of these retirement benefits and there's a clear understanding of what that transfer looks like. You can start the Quadro process, early on, right away.
That brings us perfectly to the next topic where we see the litigation. And I'm sure Saraphoena has some anecdotes to share as well. The thing that we see a lot of is when the opposite of what you're talking about, Jenny, when the divorce happens and then a period of time goes by, and sometimes it's a lengthy period of time, 10, 12, 15 years, and no Quadro or DRO is entered. So let's talk a little bit about what we see in litigation, post-judgment litigation, when there's been a delay of some period in getting that DRO entered, whatever type of DRO it might be. Saraphoena, do you want to first, do you have any comments that you want to say about the process that Jenny was talking about?
Yeah, so I have not had the same experience with regards to IRAs not being able to, or rather the IRA custodians not being able to honor a predated, like an earlier valuation date where they measure the gains and losses. Some of them won't do that. They won't calculate gains and losses, but I've actually been able to have some of that happen. So, but again, you have a variety, part of the problem or part of the difficulty with Quadros, EDROs, CoApps, and orders of assignments for IRA or transfer documents is that there is such a variety across all the various different custodians and plan administrators with regards to what they will or will not, be able to do to accommodate the wishes of the parties. A lot of the post-judgment litigation and the case law in the Court of Appeals really reflects, like, when we kind of, this is going to sound silly, when we strip away the law from these opinions and we look at the language that, the seed of discontent that starts the whole problem, right? we're coming down to what language are people using in their judgments of divorce. I do echo Jenny that you can't start this discussion early enough. I prepared the how-to kit for how to handle the Quadro process with regards to ICLE, and ICLE has an amazing wealth of information, a lot of it provided by Jenny as well, on what the difference between the plans are, how to address it, what you need, so on and so forth. Starting early by figuring out what kind of plan it is, getting the summary plan description, learning about the aspects, having that information early will allow people to avoid the missteps that led to all this post-judgment, delayed entry problems. It can be as simple as getting a plan statement and the summary plan description. Even if it's your own client who is the participant, who doesn't have that information and is having difficulty talking with their HR to get that information, even sending a friendly subpoena to your client's own employer saying, hey, can we please have this information? And then either turning it over to Jenny or somebody like Jenny or handling it yourself. It's a surprising shortcut around things to dispute at mediation. Because most companies that I've ran into have sample Quadros. There's sample EDROs for the state plans. There's samples. A lot of the times when people are talking about what information do we put into the judgment, we're thinking, what do we need to fill in those blanks? Because these sample Quadros, you can't really mess with them too much. You can't really play around with the language and have creative drafting. If the company says this is their sample, then you're filling in a couple of blanks, right? And so really getting that sample Quadro or the sample EDRO is the number one, like if I had to give a number one top tip for what should you do to avoid a problem with pensions or IRAs later, get your hands on that sample Quadro. A lot of the times it's just not that mysterious. But again, back to the case law, like in DRCO, the one that was from 2018, 2019, that went to the Supreme Court about the statute of limitations, and Johnsen, which DRCO overruled, and in the Hine case and all these other cases, you get to see that they're talking about the Quadro itself versus the right to actually have the asset. I like to think of Quadros as a conduit. It's not the right itself, it's the method of payment. Kind of like, I think of them similar to like, well, you have child support, you have a child support obligation, and the UXO and MSDU in front of the court provides how it's being paid, okay? So when you have, and this is kind of the reasoning behind DRCO, if you have a judgment that says wife gets 50%, well, that 50%, they're entitled to it when it starts getting paid out or when it could be paid out. The Quadro is a way for the money to come directly from the company. But if there is never a Quadro, that doesn't mean that the participant, when they start receiving 100% of the pension checks, they're supposed to do a direct payment. We're so very familiar with the idea of direct payment, opting out of child friend of the court system and doing a direct payment of support and keeping track of it versus having it kind of handled from income withholding. And this is a very similar corollary, which is where DRCO was, DRCO and Johnsen to a certain extent, were standing for the principle that the statute of limitations doesn't prevent the delayed entry of the Quadro, which would be the method of payment, but the statute of limitations can limit the alternate payee's ability to recover benefits that had already accrued.
From that conduit?
Not from the conduit. So if people are getting divorced in their 20s, or let's say 30s, and they've acquired some sort of retirement defined benefit, that's going to be able to be distributed when they're 54. If they, wait until the person's 54 and get the Quadro entered, or even if not, I'm just going to stereotypically say the husband. Say the husband starts getting his pension payments at age 54 and there hadn't been a Quadro. Well, that's when the right to collect is beginning. If he's applying the judgment, and if it says wife gets 50%, then when he gets it from the company, he should be doing a direct pay. But that's such a hassle, which is where the Quadro comes in.
Yeah.
It's the unhassling order.
Right. So there's two things related to that. One, just to be clear for everybody, that in both Johnsen and DRO, there was a significant delay between the judgment of divorce and the entry. And in DRO, the person had retired before the Quadro was entered. And so there was like this 2-year period where there was, I think it was the husband, I can't remember. The husband was getting money when he was only supposed to get 50%, he was actually getting 100%. And this leads to one of the questions that we have in the chat. So I'm going to read that as well and make sure we're answering it directly. And in Johnsen, it was like a 12-year delay, but at least the person hadn't retired, because it gets really messy, I think, from what I've seen, once a person retires, because that's when the spouse who has a pension in their name, they start getting money. And then the question is, how do you get that money back? So the question in the chat, let me read this out loud. What happens when the judgment divorce provides for the division of the asset? Then you have the delay that I referred to. But in the interim, the payee has used the asset via withdrawals, loans, etc. So there's not enough money to satisfy what was awarded. So I think I know what the answer is, but I want to hear what you guys have to say.
A motion to enforce, because they used it. Once the judgment says party A gets X amount, that X amount belongs to party A. Then they have 10 years from whenever, even if it's not divided yet, they essentially have, according to the statute of limitations, 10 years from the time that they could have gotten it to take it.
Which is not the time of the judgment of the divorce. It's the time.
Not always. Sometimes it might arguably be, right? So for an IRA or 401k, where you could theoretically roll over, and none of these cases have this fact scenario, so we're just kind of like espousing our opinions here. But if it was a 401k or IRA, then it could be rolled over starting from the date of the judgment and arguably 10 years after that. But when we're talking about pensions or things that can't be rolled over, can't be taken out, or can't be segregated until a future date, like an early risk retirement date, or when they actually retire, one of those floating future date occurs, then that's where the 10 years begin, which is where, like you were saying, in DRO, pay status began, and then 2 years later, you have the discussion about, if the wife in that case had waited 12 years, then it's a rolling 10 years per every single monthly payment. So it's not even like there's
it's accruing every month, just like child support, like a child support.
Right.
Yeah.
So if she would have waited in that case until 22 years after, then she could only go back, 10.
Yeah.
Versus.
Right.
Right.
Jenny, do you have any thoughts about remedies in that situation?
Well, so anecdotally, I've encountered both delays from a defined contribution standpoint and a defined benefit standpoint. So the horror story in the defined benefit plan scenario, there are a couple, but I had a case a number of years ago where the parties waited 13 years to get a Quadro implemented, or sought to get a Quadro implemented. At the time, right around the divorce, right after, there was some communication. There was a Quadro submitted to the plan administrator. It was rejected. So there was some activity way back when. And then I think it just was too hard to figure out what the heck was going on. So they just moved on with their lives. And then I was contacted. So I drafted the Quadro. It was a fairly simple Quadro, actually, with a sample, like Saraphoena says. We get it entered with the court, send on to the plan administrator, and lo and behold, it's rejected because several years prior to that, the participant in the pension plan was offered a cash lump sum buyout. So basically, rather than take a monthly benefit at some point in the future, participant, we'll give you $80,000 now, and then we don't owe you anything more. Well, he took it, and in doing so, he had to fill out a certification form that says there are no pending quadros in this matter. Well, he's a lay person. Maybe he realized that there wasn't a quadro that was implemented all those years ago. Maybe he, he was being sincere that he didn't know. So he genuinely thought that there was not a pending quadro and that everything was divided up. So they paid him his money and he spent it. So he spent half the money that was otherwise entitled to go to the alternate payee, and he was uncollectible. So then what happens? She's out of luck.
Out of luck.
You can't get blood from a stone. On the defined contribution side of things, one thing that I see very, very frequently is, for whatever reason, there are delays in getting these 401k quadros implemented. And the judgment of divorce will say something like, the alternate payee is awarded $50,000 as of the date of judgment. Okay, then 5 years goes by and nobody sought to get a quadro. You do the quadro, and then all of a sudden the other side says, well, this says that the $50,000 is subject to gains and losses from the date of judgment to the date that the funds are actually transferred. I didn't agree to gains and losses. I thought it was just a $50,000 straight lump sum transfer. So then you have this situation where there's not necessarily a meeting of the minds on the gains and losses, which could be huge, a huge amount of growth over that period of time. And I have seen a lot of judges, in these motions for entry of these quadros or motion to enforce the judgment and get these quadros entered, they say, sorry, it's a $50,000 lump sum transfer, which I don't understand, because but for this conduit, like Saraphoena was saying, the money was awarded to this person as of the date of judgment. It happens to be sitting in the participant's name until this quadro transfers it to the other person, but it's still that person's money. So then when you have a situation where the gains and losses are excluded after, and the significant period of time goes by, really the gains on that person's $50,000 go to the ex-spouse, and then the alternate payee just gets the flat $50,000. And I just had a case I was involved in. I wasn't the attorney, but 6 years had gone by and the alternate payee was entitled to about $300,000 6 years ago. Her attorney filed a motion for enforcement of the judgment of divorce because the transfer had never taken place. And the judge said, sorry, she only gets $300,000. She doesn't get any of the gains and losses from date of entry of the judgment. So, it does make a difference, this time period that goes by, not just in defined benefit plans, but in defined contribution plans. And that's why, like Saraphoena says, it's critically important that your judgment of divorce uses the correct language and you make sure that you check all the boxes on what you need to resolve. And the only other thing I would say about the defined benefit plans and the delays and those pension plans and the delays involved in getting those quadros implemented is, once a person is in pay status, once a participant is in retirement status, it's no longer the case that you can draft a quadro that's called a separate interest quadro, which is based on the alternate payee's life expectancy. So in that situation, you either have to provide for some sort of qualified joint survivor annuity benefit or some sort of security for the retirement plan. Otherwise, the alternate payee's benefit is going to be based on the participant's life expectancy. And once the participant dies, the alternate payee's pension benefit dies with him or her. So just bottom line is, it's really, really important to just get these these quadros and these court orders entered as soon as possible before or after entry of the judgment of divorce, so you can avoid potentially leaving a lot of money on the table.
Okay, now this, I have three things. One, did you just say if the pension holder or the participant dies before the quadro is entered, then the recipient's out of luck? Is that what you said?
No, if so,
Oh, sorry.
let's say somebody is an alternate payee is awarded 50% of a GM pension plan. I'm just going to use that for an example, and then there is no quadro,
Right.
and then the participant actually retires and starts receiving his or her pension benefit, and then you get the quadro implemented. In that situation, because the person's already retired, there's the plan administrator will not accept a separate interest quadro that would base the alternate payee's pension benefit on his or her life expectancy. It has to be based on the participant's life expectancy.
Oh, okay.
So that would be what we call a shared interest pension plan. And you know, there are differences between a separate interest pension quadro and a shared interest pension quadro. One of them being that if the alternate payee dies in a shared interest pension quadro, the alternate payee's pension benefit goes back to the participant, regardless of whether they've been divorced for 10, 20 years.
So we have a few questions from the audience. I'm going to try to fit them in where they belong. One is,
Hold on.
Okay.
Can I have a question?
Yes.
Just a comment and a reminder that the gains and losses, because there's other horror stories where, for example, if the alternate payee would have been awarded $300,000 before a market crash, and then it crashes, and then the $300,000 is no longer 50% now. Well, it's like 75, 80%. And so, I mean, sometimes that financial security of not being subject to market fluctuations, if, for instance, you know, the market's very volatile, people sometimes do specifically negotiate to not have the market gains or losses included, which is why, you know, I mean, when getting back to like the Hine case and other cases, where really look at what was actually the intent of the parties when they draft. It gets down to contract interpretation at the end of the day. Why did you write what you wrote? Was there an actual reason for not saying market gains and losses? Is there any evidence of that actual reason? Was it an oversight, a mutual mistake, or was it intentional?
Got it. Now, one question for the audience is there a court rule that determines which order governs when there's a conflict between the judgment of the divorce and the quadro? And you used that example earlier when the judgment of divorce says something that just can't be done. And so, you know, I don't know if I don't think there is a court rule, but Jenny, what do you say about that?
My understanding was that the quadro language controls, and so that's why a lot of times I will reserve the intent of the parties as expressed. That's one thing I add additionally sometimes to sample quadros that I receive, that to make sure that the party's intent as expressed in their judgment of divorce is maintained. And then if there is a situation where the domestic relations order does not match the intent of the judgment of divorce, and there had to be some kind of fundamental substantive revision of what their agreement was so that it could actually be implemented, I usually suggest that the parties do an amendment to their judgment of divorce, just so that the record is clear. This is why this document does not match. This is why this quadro, this domestic relations order, is not consistent necessarily with the terms of the judgment of divorce. People might think that's overkill, but I just, you know, as time passes, sometimes people will look back and say, well, why the heck did the quadro say this when the judgment of divorce says that? And I would just to err on the safe side, I think it's always better to be very clear. and preserve what intent needs to be preserved in the Quadro itself, and go that additional step in doing an order if it really would make things more, bring more clarity to the parties on why you did what you did.
And in further answer, the Quadro is often a lot more specific than the judgment. The judgment often contains very generalized language. If it's a consent judgment, I think most of the time we're talking about consent judgments. When it's a consent judgment that contains just a one sentence reflection of party intent, and then if they were to sign a 3, 4, 5 page Quadro that is very specific, then the court can, I'm not saying in every single case, but some arguments or options would be that the Quadro is more specific than the general language in the judgment. So specificity over generalities is one option or one argument. Another might be that if the Quadro was not entered contemporaneous, then that it is a later amendment to the prior contract, or it's a later modification of the prior intent. That's another argument. If they're entered completely contemporaneously, before you even get to this argument of which one should preside, the court in general will read two contemporaneous, or they're meant to be contemporaneous, contracts together as a whole. What conclusion can the court draw to read them in pari materia, which is my favorite thing to talk about, so that it's one comprehensive agreement, as opposed to, like, the court should and will likely, at least based on our experience of contested Quadro scenarios, try their darndest to make some rhyme or reason of, well, if we interpret the judgment this way, then it's not really in conflict with the Quadro, and vice versa.
So
And
I can go ahead.
I was just going to add to what Saraphoena was saying, is that sometimes parties are very specific in their judgment of divorce or their confidential settlement agreements as to what they're going to do once the Quadro is entered, that someone is going to, take a cash distribution of $50,000, and then they're going to use that to pay down these following joint bills. That language does not have to be in the Quadro. The plan administrators couldn't care less what you're going to do at the distribution stage. So a lot of times that's part of the agreement is just left out of the Quadro altogether, but is still enforceable. It's still part of the party's judgment of divorce, and things like that. So, that's one area where the judgment of divorce might be slightly more specific than the Quadro. But if you add that language to the Quadros, whenever I've seen attorneys that have drafted Quadros and then add that language that is like, here's what we're going to do with the money, those are usually rejected by the plan administrators, because I think it just confuses things and they're not really sure what to do with that. So they just kick it back.
Right, because it kind of goes against the whole purpose of Quadros to begin with. Way back when I read, well, for whatever reason, I had a case where we had to research something like it was like 20 years ago, the judgment was entered. What do we do now? Right? One of those cases. I remember going through the old family law journals from like the 80s. And I found something from like 84, somewhere between the 84, 87, when I was in kindergarten, right? That time period where they were talking about the purpose, and essentially that, you have the because it wasn't until I think 1984 when pensions were even considered marital property, the REA or whatever. I don't remember what it's specifically called for, but so it was this new concept of that it's even a thing, it's even an asset. It seems so obvious to us now. We have homes and retirement as the biggest assets, but before 84, it wasn't a thing. And then suddenly you have these pension and 401k, these companies who are getting these like 30-page judgments, and then they got to like leaf through them. No. Right? That's my interpretation of my cartoonish view of what the government essentially said. Like, we got to streamline this process, which is why when, in the actual ERISA provision at 26 USC 1056, and like 414, I think it's P.
P.
You know, like that's what it's really streamlining it. Just give the Quadro company, the plan administrator, what they need to know. The requirements for Quadros to be a Quadro are like the basic requirements are laughably tiny. You need their names, addresses, the amount, the name of the plan administrator, essentially. You know, it's very, very small. But then these companies, I find the bigger the company, the more stringent they are about their sample Quadros. Why? Well, because they got to process them. They can't spend 5 years trying to process a Quadro. So having uniformity so that they can just process them quickly without a lot of variety it's some companies are very, very strict about it. I had one case where there was, it wasn't a, I think it was an EDRO. It was like out of Ohio or Indiana, one of these other sister states, where it kept getting rejected. We would enter it, we would send it to the plan administrator, they would reject it, we'd scratch our heads, we'd amend it in some way. After many, many, many months and a lot of back and forth, and it was a contentious case to begin with, it ended up being that it kept getting rejected. We could never get a hold of anybody because of the margins. All the language was right in the Quadro, in the EDRO, but it didn't have like 1 1/4 margins, which means that the layout shifted slightly. Rejection.
It's like the Register of Deeds.
It's like a register of deeds, right? Because they got to review it. They got to know, you know. Yeah. And it was wild. But yeah, those sample Quadros, which again, just if anytime you have a client who says, well, there's some retirement form. Yeah, I don't know what it is. Oh, well, where did your husband or where did your wife work? Let's just turn to that person, you know, that entity. Can you give us a model Quadro? And then in mediation, it's just a matter of like, okay, here's the 5 things that we got to fill in. That's all we really need. Like it's not rocket science here.
So from some of the audience questions, it does seem like a lot of people have experienced situations where one spouse is not getting the benefit of the bargain or the benefit of what the judge ordered after divorce, and they're being shortchanged in some way, maybe because of the delay. I didn't know if you have, Jenny, if you have any more thoughts about remedies. To me, it sounds like you have to enforce, like Saraphoena said, or get a judgment for the amount that's already been already been received by the participant that's no longer part of the plan. And if they are illiquid, like you had the example, they didn't have any money, the person's out of luck.
Yeah, I mean, it's really tricky sometimes to right the ship once it's wrong. I would say if this is a really prevalent problem for practitioners, they can do their part just by being careful when they draft their judgments of divorce. You know, for example, for a 401k, 403b, those kinds of things, I think it's really, really important to put, if you're going to do a percentage or a dollar amount, that's not the end of the story. Put the percentage or dollar amount in the judgment of divorce, but you want to put a valuation date in there, and you want to address whether those dollar amount or percentage is going to be subject to gains and losses from that valuation date to the date the funds are actually segregated for the benefit of the alternate payee. Same thing with, you know, for 401ks, 403bs, you want to address the treatment of any outstanding loan balances. Because let's say you have a retirement plan that has $100,000 in it, but there's a $20,000 loan balance associated with the retirement account. So the Quadro is going to have to state, how is that loan going to be treated for purposes of calculating this alternate payee's benefit? Well, if it's a dollar amount, as long as there's enough vested, you know, retirement assets in the actual account to effectuate the full dollar amount transfer to the alternate payee, it doesn't really matter. But if you're doing a percentage, is it a percentage including the loan balance, or is it a percentage excluding the loan balance? When you say including the loan balance, that means you use $100,000 as your starting point. So if the alternate pay is getting 50%, he or she's going to get 50% of $100,000. If you say the loan balance is excluded, that means you're taking 50% of $80,000. And so it's always been the including and the excluding, to me, was always counterintuitive. Like when I say, well, we're going to include the loan, that says to me, well, we're going to take into account the fact that there is a loan, and so we're going to reduce it. Well, if you include the loan, that means you basically assume that there is no loan. The participant has to, there is no ability to transfer loan liability in these quadros, so the participant is going to be stuck with the loan balance. So that's another area where there is sometimes confusion that can be resolved at the judgment level by just addressing that.
And when resolving it at the judgment level, if like, I'm with you, Jenny. I have a hard time keeping straight the including, excluding. I don't know why. Like I hear the words, I can write them down. So as a practice tip, if there's also kind of, I've had friendly discussions with opposing counsel about including, excluding, wait, which one does it, just put an example, including loan balance, right now there's just spell it out in the judgment. You can't really do that in Quadro. You'll risk getting, but at least it's clear what the intent is, even if the terms of art aren't used correctly.
Sometimes I see footnotes where right in the bottom, the attorney will write, well, this loan was taken out unilaterally by the participant for purposes of paying, separate expenses or something like that. So then right there, that clues into my mind, well, they mean to include the loan balance for purposes of calculating the alternate payee's benefit, because it wasn't the alternate payee that should be on the hook for 50% of the loan, because it only inured to the participant's benefit or something like that. So footnotes are good. If you're confused, examples, I'm totally with Saraphoena on that one.
So a few more questions about the delay and what happens when there's delay. For example, what if in between the judgment and divorce and there's no quadro entered immediately and the participant retires? What happens then? Can a quadro still be done, etc.?
Yes. So the quadro can still be done, but in a defined benefit plan situation, like I was speaking about earlier, that it just kind of muddies the water a little bit, because you have to plan for what happens if the participant dies, because generally speaking, if they've already made their form of payment election, so they might have elected a straight life annuity, which basically means that once the participant dies, the pension benefit goes with that participant. You can't do a separate interest where there's essentially the alternate payee's benefit is separate and apart. So you have to account for that in some way, which wasn't necessarily a fact that was anticipated at the time that the judgment was entered. And then the other concept, which is most pension systems are, if somebody's in retirement and then a quadro is entered dividing up the retirement, and the parties are plugging it along, participant is getting half of the pension and the alternate payee is getting half of the pension, and then the alternate payee dies, the alternate payee's benefit reverts back to the participant. So, and it's always seemed like, well, that's a raw deal. I mean, the pension was the asset. It was the alternate payee's separate asset. And just because there was this delay in the quadro entry, that means that his or her 50% went back to the participant, which could be an ex-spouse from 10, 20 years ago. And I've had arguments like that where, you know, I've actually had arguments where the person's not in pay status yet. And so you can do a separate interest quadro for your alternate payee, and then the participant says, no, I'm not in agreement with that. I want it to be a shared interest quadro. So then you start getting into a fight about what form of payment or what type of quadro you're going to be entering. And it just makes my head want to explode, because I'm saying, well, how is the participant sitting there saying that we should do a shared interest approach to this when we could use a separate interest approach? And the reason being, the participant has an interest in it being shared, because if the alternate payee dies, he or she gets the other half of the pension restored to him or her. So again, it's just, it all boils down to delays are really, really bad.
Yeah.
Well, also when you have with pensions divided pursuant to the coverture, a lot of our discussions and our talk about, you know, first wife, first alternate PAE, getting this windfall, you also have to consider whether or not maybe the participant has had multiple spouses. That where the, you know, in a coverture fraction, where the first spouse would get 50% of the years of marriage over the total years, and then spouse two, alternate payee two, would get some, you know, of different chunks. And it gets, you know, I mean, it's no small task for these plan administrators to figure out, you know, what to happen. I have had a situation where, and I'm going to switch just to the military pension, because the survivor benefit plan is considered separate and it has its own timelines in regards to, you have to submit it within X period after the judgment, not necessarily having it tied to the end of retirement, but tied to when the agreement or when the judgment was entered. And
wait, is that for the military ones only?
That the survivor benefit plan, it's former spouse survivor benefit plan with regards to the military.
Okay.
That I'm talking about. That's like a completely separate life insurance policy. So we've had situations where it wasn't awarded, and if the question from the crowd is, well, what do you do? One option is if the participant failed to do what they were supposed to do and it's lost forever because you're up against the US government, and what are you going to do, right? One option is that the trial court could, you know, I don't want to say as a sanction, but as a part of enforcement, if the alternate payee was supposed to be getting the survivor benefit and now can't, they can order, the trial court can order the participant to obtain a life insurance policy. Okay, you know, so that when they die, the other person can have, even though it's not from the government, but it's at least some sort of benefit. There are some ways to have creative thinking when you do get kind of, I don't want to say locked out by the plan, but something to that effect, where just because it's, you know, they retired and selected a single life annuity, and what are you going to do, right? Where they can't change it. Well, having, you know, more specific language, or, you know, just making it very clear from the court that when the annuitant receives the money, they have to make the payment themselves, or they have to keep track of it, or, you know, consequences if they don't. Because again, the Quadro, EDRO, CoApp is a conduit, right?
So Jenny and Saraphoena both, I know there's some like things that you want everybody to be aware of, and we're getting, we have like 6 more minutes. So I just want to make sure we have time to, like, what are the things that people should be on the lookout for, or tips that you have for the attorneys in the audience to make sure that they're, you know, aware, and some of the tips you've already provided, so you don't have to repeat, but I know there's some things that you haven't addressed yet.
Well, I would say number one, I guess, again, this relates to delay, you know, in getting the quadros entered, but sometimes these plan administrators are changing over the years, and a lot of them will not honor or calculate gains and losses on a valuation date that predates their being the plan administrator. So one that's pretty common in our area is Spectrum Health 403B systems, used to be managed by Voya as the plan administrator. Now they're under Prudential. And Prudential took over as of January 1 of 2021. So it flat out says, if you have a valuation date that's anytime before January 1 of 2021, we're going to reject your Quadro because we can't calculate gains and losses. So that becomes tricky to try and figure out how to do that. I think I saw a question. A lot of times people will have multiple retirement plans. You know, the plaintiff will have 5 retirement plans and the defendant will have 3, and they'll say, well, we want to just do one Quadro to save money with a net transfer. And you can do that for defined contribution plans, obviously defined benefit plans. You can't do that, but for defined contribution plans and IRAs and things like that, you can do that. But if you're doing it, you need to use the same date for all of the account statements. So I sometimes I'll get an account statement from October 3rd of 2021 and March 3rd of 2022, and they're trying to equalize these accounts. And so that can make it really, really tricky. So those are just a kind of a couple tips that I would just recommend you keep an eye out for. As you certainly can net out an equalization transfer, but you're going to want to use a consistent valuation date. And
and how do you get the same valuation date? I'm assuming that a lot of these plans might have a monthly statement or something, but they probably issue them on different days of the month.
Yeah, it's kind of tricky. Sometimes people use an easy one like 12/31. Those are usually and
consistent.
Yeah. So and usually use closest available valuation date, but you want to make sure that you get as close in time as you possibly can if you're going to do that net transfer.
Can you tell us, you had mentioned when we met the other day about possibly having the administrator freeze the plan. Can you tell us what that is? And how likely it is?
Well, I don't know, Saraphoena, so there is a provision within the 26 USC 1056 that, pending qualification, if you do submit a notice to the plan administrator, it's similar to putting a lis pendens on real estate, so it can't be sold. Plan administrators have a massive amount of flexibility with regards to whether or not they're going to grant these things, but it's better than nothing, right? And if you have maybe a draft Quadro or a Quadro that you guys are, just letting the plan administrator know something is going on. It might not guarantee, but it can certainly result in, maybe triggering the 18-month hold, because a plan administrator has the ability under ERISA to put an 18-month hold on distributions from the plan or being able to go into pay status pending resolution. So, that's a pretty good amount of time to go into things. I know Jenny has something visual on the screen. My only hot tip that I was going to say is specify pre-tax or post-tax if you are specifying a lump sum in your judgment, and if there happens to be a delay. And for example, if there was that $300,000 lump sum, and if the market had tanked, and if it's not in the plan anymore, then are we talking about, is the alternate payee on a motion to enforce going to be awarded $300,000 real post-tax dollars, or the pre-tax equivalent, which would be substantially less? I'm guilty of this as well, but I'm trying to do better going forward.
So I have one last question. So a lot of what we've talked about today has been like the problems that the recipient faces if things are not done properly or quickly enough. Are there any things that the participant should be concerned about? Like, is most of the risk on the recipient, or is there risk to the participant as well?
Well, the risk to the participant as well, because it holds them up. like until such time as the alternate payee's amount can be segregated, then there also can be tied up. If they want to take out an extra loan, are they going to be held in contempt? If they want to retire, do they have to wait? You know, and a lot of times I found that the participant assumes that the alternate payee is required to prepare the Quadro because they're the one getting the money. And that is a really good rule of thumb. And I think a lot of trial courts believe that too, but I'm not aware of anything saying that it's actually their responsibility. When I've had complaints from participant clients, they just want to move on. They want to move on with their lives, and they can't, their hands are tied. So a number of times I've essentially said, listen, I know they're supposed to probably do it. Or even if the judgment wrote in, they're supposed to do it, but we'll actually let's just get it done. Let's just get it over with, because parties in a divorce action need closure. That's the whole thing. The whole point of all of it is to separate and be done with each other. And the Quadro, this last little thread, really does prevent final closure.
In cases like Johnsen and DRO, where they're litigating about the entry of the Quadro 10 to 15 years after the divorce, does not give closure in the way that you're talking about. And not just litigating, it's litigating in the Court of Appeals, in the Michigan Supreme Court. It's like never-ending litigation. So we want to avoid that at all costs.
Yeah. And I would say under the EDRO Act, the recoupment problem is a major problem for participants, because those retirement systems are based on a retirement age 60. So anytime a participant is working past age 60 and the alternate payee has an early retirement option checked in the EDRO form, it could result in a pretty significant reduction in the participant's pension benefit once that participant goes to retire. So you have to be really, really careful to address that if you're dealing with any kind of retirement system under the EDRO Act.
Great. Well, Jenny and Saraphoena, thank you so much for being with us today. We have a few questions that we did not get to, so I'll make sure that I circulate them to you with the person that asked the question, so we aren't leaving them hanging. And we will be circulating takeaways probably next week, which will include this wonderful chart that Jenny prepared for us. So just stay tuned on that. Again, you guys have a great day, and thank you for being with us.
Thank you.
Thank you.